Well, good morning. Looks like we're recording now. Thank you very much for having me. As Scott mentioned, my name is Tony Dalimonte. I'm an attorney at Foster Swift Collins and Smith, which is a member of your association, and I work in our employment group. So we've been dealing a lot with this new sick leave change. I'm going to be talking about the new paid sick leave laws that will be going into effect in February of 2025. Um, if some of you, some of you may recall that there's a lot of chaos in the courts, and lots of people thought this was going to go into effect in February of 2023. But because of appeals and things that in the courts that have happened, that was stayed. So, we prepared, and we had a lot of clients prepare 2 years ago to get ready and review their policies and review their handbooks to have this law go into effect. And then, now we're finally here at that point again. So what I want to talk about today is I want to review the current sick leave law that we have in place. I'm going to give you a little history lesson of how we got here because it's pretty interesting. And I'm going to run through a comparison of the new law versus the old law. And I'll talk a little bit about what you need to do to get ready. So with that, just a brief refresher on the current Michigan sick leave law. It's called the Paid Medical Leave Act, which came into place due to actions by the Michigan legislature in 2018, which is the subject of the recent ruling by the Michigan Supreme Court, and we'll talk about that shortly. But for the moment, Michigan sick leave law is the Paid Medical Leave Act. It only covers individuals that employ or companies that employ 50 or more individuals. So there's lots of small businesses that haven't had to provide sick leave to employees. And under the current law, employees accrue 1 hour of paid sick leave for every 35 hours worked, up to 40 hours annually. But the big thing here is that employers have the ability to front load that time. So you can give 40 hours at the beginning of the benefit year and not have to worry about carryover or sort of accrual obligations. And there's lots of exclusions as well. There's exclusions for seasonal workers, part-time workers, variable hour workers. And this is all going to change come February 2025. So big picture is, again, February 21st, 2025, the Earned Sick Time Act will replace the Paid Medical Leave Act. And this date also applies to changes in Michigan's minimum wage. I'm not going to cover that in detail here because I understand that that's not really an issue for you all. But if you have any questions on it, I have a slide at the end that we can go through. Essentially, what's happening is the minimum wage is gradually increasing, and the tip credit is going away in a few years. So this is going to be a big deal for restaurant owners. Okay, so time for a history lesson. I told you I'd give you a history lesson on how we got here, and in order to do that, we need to rewind the clock 6 years ago. So in 2018, two ballot initiatives were circulated to change the sick leave and the minimum wage laws that are in effect. And so what is a ballot initiative? Ballot initiatives are proposed laws that are generally put on the ballot for voter consideration. And if the initiative receives enough votes, or enough signatures, it becomes law. In Michigan, our Michigan Constitution permits citizens to create these ballot initiatives if you obtain enough signatures. So the individuals in Lansing and Detroit and Grand Rapids, if you see people with the clipboards and they're out there, trying to get you to sign something, this is really what they're doing it for, where, if an initiative receives enough signatures, it can go on the general election ballot. And, just for fun, I think the number is 350,000 votes are needed in 2024 in order for a statute to go onto the ballot. Michigan's one of 24 states that allow this sort of citizen-led ballot initiative procedure. And so again, in 2018, two of these initiatives came up. They got enough signatures, and one of them was the minimum wage, and the other was the changes to sick leave. The first ballot initiative is the Earned Sick Time Act, which we'll talk about in detail today. And it sought to significantly change and increase the amount of paid sick leave employees in Michigan would get for the reasons specified in the initiative. And we'll go into it in greater detail, but just wanted to prime you with that. And then the other was the Improved Workforce Opportunity Wage Act that got enough signatures to go onto the ballot. And again, this sought to raise the minimum wage and eliminate the tip credit. So why haven't these laws been the law in Michigan since 2018? Well, the ballot initiatives are generally placed on the next general election ballot, provided that there are enough signatures. When the initiatives get enough signatures, the legislature then has three options. They can adopt it as written, they can reject it, in which case the initiative goes on the ballot for you and I to vote on, or they can propose an alternative, in which case the initiative and the alternative go on the ballot for you and I to vote on. So what did the folks over in Lansing do in 2018? The legislature used a unique and now unconstitutional tactic called adopt and amend, where they adopted the ballot initiatives as written, and then they immediately amended both laws before they became effective. So that's how the Paid Medical Leave Act and the Amended Wage Act came into effect in 2019, and that's what we've been doing for the last 5 years. And so the amendments significantly changed what would have been required if the ballot initiatives had been approved. So the amendments essentially made the sick leave law in Michigan much more employee friendly or employer friendly. And again, we've already talked about the Paid Medical Leave Act, but they changed it so it only applies to 50 or more employees. There's lots of exclusions. The accrual time is increased. You can avoid the carryover and accrual requirements by front loading. All of these things that only happened because of the amendment by the legislature. And then same thing with the minimum wage law. That was significantly amended. So they did away with the provisions that would have eliminated the tip credit. They spaced out the minimum wage increases over time. So those are the changes that happened there. So once the amendments were implemented and were law, a lot of individuals and organizations cried foul, saying, no, you can't do this. This adopt and amend procedure is unconstitutional. So in 2021, an advocacy group called Mothering Justice filed a lawsuit in the Michigan Court of Claims arguing that this adopt and amend tactic was unconstitutional and sought to invalidate the amended Paid Medical Leave Act and the amended version of the minimum wage law. And in 2022, the Court of Claims ruled in favor of the advocacy group and held that, yep, this was unconstitutional. You can't amend it this way. We're going to put those original ballot initiatives unamended back into place. And this got a lot of publicity and discussion. People were like, oh crap, we got to get ready to put these new sick leave laws into place. And so the court stayed enforcement of that law until February of 2023. And so we were telling our clients, get ready, February 2023, these original versions of the law are going back into place, kind of like where we're at now. But prior to expiration of that stay, the Court of Appeals reversed the Court of Claims decision. They disagreed with the lower court's decision, finding that, yeah, the Constitution actually permits this adopt and amend procedure. And the Court of Appeals took the position that the sort of underlying subject of the initiatives were irrelevant, and they found that it was, they were permitted to do this. And so, many of us thought that the Michigan legislature may pass new bills implementing a minimum wage or a sick leave changes to avoid all of this chaos in the court, but that never happened. So then that decision got appealed to the Michigan Supreme Court, and that gets us to where we are now. A little over 2 weeks ago, on July 31st, 2024, the Michigan Supreme Court held that the adopt and amend tactic was unconstitutional, and that the original unamended versions of the Earned Sick Time Act and the Improved Workforce Opportunity Wage Act will be going into place, will be reinstated, and it will be effective February 21st, 2025. So that's the history and how we got here. So now you can go back to your friends and family and tell them about all these interesting facts about why the new sick leave and minimum wage laws are going into place. So now I want to dive into what are the changes? What do you need to know? What do you need to be worried about as you are implementing changes so that you can be compliant with these laws? Big picture, what are we talking about? So the Earned Sick Time Act, that original ballot initiative from 6 years ago, is significantly more pro-employee than the Paid Medical Leave Act. It provides greater employee eligibility. Nearly all Michigan employers are going to be required to comply with it. It increases the accrual rate of sick leave. There's broader reasons for use. You have to allow carryover. Basically, there's a whole lot of businesses who've never had to do this before in Michigan who now have to. And there's significant penalties for violation and not complying with the law. So we're going to dive into all these things that I just mentioned, but that's the sort of primer and big picture changes that are happening. So let's look at the main differences in a little bit more detail between the Paid Medical Leave Act and the Earned Sick Time Act. Again, the big change is that under the Paid Medical Leave Act, if you're a company with 50 or more employees, you had to comply. If you had less than 50 employees, you didn't need to provide paid sick leave. Now, under the Earned Sick Time Act, employers with one or more employee have to comply. The accrual rate is increased or is faster under the Earned Sick Time Act. So now employees will accrue paid sick leave at a rate of 1 hour for every 30 hours worked, up to 72 hours of paid sick leave, which means that companies have to give up to 9 days of paid sick leave under the Earned Sick Time Act. And there's differences between large employers versus small employers that we'll get into. But a small employer has less than 10 employees. Small employers have to provide up to 40 hours of paid sick leave and 32 hours of unpaid sick leave. So 5 days of paid sick leave, 4 days of unpaid sick leave. And now companies are going to have to carry over unused paid sick leave under the Earned Sick Time Act. And that's a big change because it's going to be an administrative burden on companies to sort of track and figure out, what needs to be carried over every year. Now I want to go into, each of these individual topics that I've sort of touched on. Again, employer coverage, I've mentioned it already a few times, but the biggest difference is that all Michigan employers, if you've got one or more employee, you have to comply with the Earned Sick Time Act. Eligible employees, this is another huge change. So under the Paid Medical Leave Act, there are numerous exclusions for independent contractors, seasonal employees, temporary employees, part-time employees. Now, under the Earned Sick Time Act, those exclusions are no more. So the definition of an employee under the ESTA is an individual engaged in the service to an employer in the business of the employer. That's an incredibly broad definition. So the takeaway here is that many more employees who are not currently subject to paid leave obligations will now be covered under the ESTA. Accrual rates, I've touched on this a little bit. So under the Paid Medical Leave Act, you accrue 1 hour for every 35 hours worked. That's getting faster under the ESTA. Now it's 1 hour for every 30 hours worked. So employees will accrue paid sick leave faster under the ESTA as opposed to the Paid Medical Leave Act. Accrual cap. So under the Paid Medical Leave Act, employers could cap an employee's sick leave accrual at 40 hours per year. Now, under the ESTA, there's no express cap on how much paid leave eligible employees can accrue in a benefit year. And one note I want to make is that if an employee is salary exempt or is salary meaning exempt under the FLSA, they're assumed to work 40 hours in a given work week, unless the employer's normal work week is less than 40 hours. So you can just assume that every week is 40 hours for the salary employees. But for hourly employees, if you have someone who's working a ton of overtime, there's a scenario where that employee accrues a ton of time, a ton of paid sick leave time during a given year. And while you can only use 72 hours, meaning 9 days, they can still accrue more than that 9 days. So employees can accrue greater amounts in a given year under the Earned Sick Time Act as opposed to the PMLA. Usage cap. So right now, under the PMLA, how much sick leave an employee could use is capped at 40 hours. Under the Earned Sick Time Act, that increases to 72 hours, meaning 9 days, for companies that have over 10 employees. If you've got less than 10 employees, you have to give 40 hours, or I'm sorry, you have to allow the employees to use up to 40 hours per year of paid sick leave and 32 hours of unpaid sick leave. So again, 40 hours, so 5 days of paid sick leave, 4 days of unpaid sick leave. So employees can use greater amounts of paid sick leave under the Earned Sick Time Act as opposed to the PMLA. Carryover. So right now, under the Paid Medical Leave Act, you can cap the amount of carryover each year at 40 hours. And if you front load, there is no carryover, which was one of the big advantages of the Paid Medical Leave Act. Now, under the ESTA, there's no cap, and you must allow earned but unused sick leave to carry over on a year-to-year basis. And again, this is going to be a big change because you, the employers, are going to have to track and build a sick time bank for employees. So, you could have a 20-year employee who doesn't use a lot of sick time on a yearly basis, but they carry over all that unused sick time every year, and they build this big bank. And of course, you can only use 72 hours in a given year, but it's still sort of an administrative burden because you have to allow them to carry over that time. But the good news is that you don't have to pay out any sick leave when an employee resigns or is terminated. So don't have to worry about that there. But you still have to allow employees to carry over that unused sick time. Front loading. So this is a big issue. Again, I've mentioned that under the PMLA, you could front load 40 hours at the start of a benefit year to avoid some of the accrual and carryover obligations. Now, under the ESTA, it's not expressly prohibited or permitted. So until this issue is tested in the courts, we can't know for sure. Um, it may be permissible so long as you're giving at least as much earned sick time as required under the statute, and you're allowing employees to accrue and carry over. But it gets complicated because the question that we get all the time is, okay, if I have to allow employees to use up to 72 hours in a year, so 9 days, can't I just give them the 72 hours up front? And the question is, or the answer is, it's a little more complicated than that because you still have to track how much they are accruing each year, and you still have to carry over the unused earned sick time each year. So if you don't track the amount that each employee is accruing, how are you going to know how much to carry over at year end? So again, it places an incredible burden on the companies to track this stuff and make sure that you're compliant. So right now, it's a little unclear whether employers may front load that sick leave at the start of a benefit year. But again, those carryover and accrual obligations will remain. Okay, so the reasons for sick leave use. So say you've got an employee and they're going to use sick leave. There's a couple buckets of reasons that they are permitted to use that sick leave under the statute. And I'm not going to go into it in too much detail, but what you need to know is that employees are permitted to use sick leave to care for themselves or a family member who are suffering from a, mental illness, physical illness, injury, or health condition. And the one area that's changing a little bit is that under the ESTA, meetings at an employee's child's school related to a health or disability or domestic violence are a permissible use of paid sick leave. So there's slightly broader reasons for proper use of paid sick leave under the ESTA. Covered family members. So the last slide mentioned, the buckets that sick leave may be taken, and it may be taken for a covered family member. The ESTA expands the definition of covered family members to include domestic partner and any other individual related by blood or affinity. Now, your guess is as good as mine what the definition of affinity is. But the takeaway here is that there's slightly broader individuals who, or I guess reasons that paid sick leave may be used because the definition of family member is a little bit broader now. Okay, so use of a combined PTO policy. So this is also the question that we get all the time. We'll get calls that say, hey, Tony, we've got a combined PTO and sick leave policy. We give more than the 72 hours that are going to be required under the ESTA. Are we covered? And again, this is a little tricky because under the ESTA, a combined paid leave policy is permissible so long as the employer provides other paid leave in at least the amounts, at least the same amounts as required under the statute and under the same conditions as those called for under the ESTA, and that is accrued at a rate equal to or greater than the rate under the ESTA. But still, the accrual and the carryover provisions will still apply. And again, the big change here is that the benefit of front loading under the Paid Medical Leave Act was you could give the time up front and then you didn't have to worry about it. Now that's not the case anymore. You can give the time up front, but you still have to do all these other, tracking and carryover things. And to be honest, we've looked at this in detail, and every policy is different. But I think there are complications that come up when you do lump in the sick leave and the PTO into one policy here, because now you, the company, has to determine which of those hours in that lumped in policy are going to carry over and which ones aren't. So it gets complicated. And again, it's putting all of the burden back onto the employer, which is unfortunate. Okay, so documentation. Can you ask for a doctor's note? Under the Paid Medical Leave Act, now, you could ask for a doctor's note following a paid sick leave absence. That was totally fine. Now it's not fine. Under the ESTA, employers have to wait for an employee to be absent for 3 consecutive days before requiring them to provide reasonable documentation justifying the sick leave. So you can't ask for a doctor's note until they're out for 3 consecutive days. And if you choose to ask for a doctor's note or choose to ask for documentation proving that, the employee used the sick leave for a proper purpose, you, the company, are on the hook for paying all out-of-pocket expenses that the employee incurs in obtaining that documentation, which is essentially saying, if you're going to require someone to go to the doctors and get a doctor's note, if they were out for more than 3 days, you have to pay those out-of-pocket expenses, which I think is ridiculous. But it's another just sort of pro-employee version of this statute. So the burden is on the employer as to documentation practices. Okay, record keeping. What documents do you need to keep around? So under the PMLA, you need to retain records for at least 1 year documenting the hours worked and the paid medical leave taken by employees. Now, under the ESTA, you have to retain records for 3 years, and you need records documenting hours worked and the time taken. And here's the big thing is if a question arises as to whether a company has violated the statute, if you don't have these records around, there's a presumption that you violated the statute. So if you get sued for a violation of the ESTA, you weren't, allowing an employee to carry over the time, or you weren't giving them enough time, even if it's a completely bogus lawsuit, if you don't have your records in place, the judge or the court has to presume that you have violated the statute. So you're already starting in a negative position, which again is a huge burden on companies and on employers. So the takeaway here is that you got to maintain records for longer, and there's greater repercussions for failure to do so. Retaliation. So this is a big one, and we're transitioning a little bit into what you, the companies, need to think about, and sort of why this is a big deal and why we're harping on our clients. You got to make sure you review your policies, because there's lots of repercussions here. So under the Paid Medical Leave Act, there is no express provision for retaliation, but now under the ESTA, if an employer takes an adverse employment action, so you terminate an employee within 90 days of any of the following, there's a presumption that you violated the statute. So if someone files a complaint alleging violation of the act, if they inform any person about the employer's alleged violation of the act, if an employee informs any person about the employer's alleged violation of the act, or cooperates with any person in the investigation of any violation of the act. If the employee opposes any policy, or if they even inform any person of their rights under the act, there's a presumption that you have violated the Earned Sick Time Act. So, I mean, where we see this going is that, if you receive a complaint that you're not in violation of the Earned Sick Time Act, there's some serious consequences if you take adverse employment action within 90 days. And this is written so broadly that if I was a plaintiff's attorney, I would tell employees, hey, just go talk about the sick leave policy, and you could maybe come within the purview of this retaliation provision. Go talk to your employees about the policy, say you don't like the policy, and then if you get fired 90 days later, there could be a presumption against the company that they violated the act. So again, you face greater risk of unlawful retaliation based on your sick leave policy under the ESTA. So enforcement and statute of limitations, this is another big deal. So under the Paid Medical Leave Act, employees couldn't actually sue companies for a private cause of action. Instead, they had to file a claim with, LARA, the licensing agency, within 6 months of a violation occurring. Now, under the ESTA, they do away with that. Employees can go right ahead and file a civil lawsuit against a company for a violation of the statute that happened anytime within the last 3 years. So again, there's a greater risk of being sued or penalized with the ESTA. And so what are the potential damages? If you do get sued, damages can include payment for used earned sick time, rehiring the employee to their previous job, back wages, reinstatement of employee benefits where they otherwise would have been eligible for those benefits. And here are the two big things. Liquidated damages, so an automatic payment of a certain amount for a violation of the statute, and attorney's fees. So this is going to give incentive to plaintiffs' law firms to start looking for these cases because they get their attorney's fees. And I think this is ripe for class actions as well. So if a company is not compliant with the statute or not letting employees carry over their time or accrue at a rate compliant with the ESTA, there's class action risk here because each violation of the statute is liquidated damages and payment of attorney's fees. So, again, we can't stress it enough that these next few months are really important to review your policies. Okay, so that was all the terrible things that could happen to you for violation of the policy and damages, and we've gone through it all. Now I want to talk a little bit about how to prepare. And this is pretty simple. You got to look at your handbook. You got to look at your existing sick leave policies, and you need to make sure that it's compliant with the ESTA and compliant with the new, minimum wage requirements. But it's handbook. We as a law firm are drafting a, sort of sample ESTA policy that we can give our clients. So that's number one. It's handbook. Look at your policies, revise your policies before February 25 or February 21st, 2025. Number two is that you need to talk to your payroll companies about tracking and internally figure out a way that you're going to track your hourly employees who are accruing sick leave to make sure that you're compliant with building that sick leave bank and making sure that you carry over the right amount of sick leave on a given basis. And training your employees on, the new sick leave law, training HR, make sure that they know you can't ask for a doctor's note. One thing that I didn't mention is notice. Does the employee have to give you notice when they're going to take sick leave? It's a little vague in the statute. Basically, it says that the employee can give notice as soon as practicable. So they just need to tell you that they're using sick leave. And again, you can't ask for a doctor's note until 3 consecutive days of absences. So train your employees, review your policies, and the last one is sort of monitor any changes. We don't think anything's going to happen to change this law between now and February 21st, but and never say never. So it could, but we're on top of it. Check the news, see if anything changes, but I would assume that these laws are going into place come February 2025. And now I wanted to open it up to questions. We dug in there. I haven't had a chance to look at the chat box as well. But if you guys have any questions, I'm happy to answer them now.
Tony, I'll start. This is Scott. First, picking up what where you just left off on any anticipated changes, I guess I'll ask Joelle, the man from our shop, if she can give an update on what the business community is doing to see if the law can be amended.
Good morning. BAM has cooperated with the Michigan Chamber of Commerce and other business interest groups. In fact, there are up to 55 people who are signed on to a letter working with legislators to get some changes. I can share the one pager that we're going to be leaving with the legislators on 5 major changes that we'd like to see to the Earned Sick Time Act. This is going to be difficult, as Tony said, because there are only a few more days left of legislative session for the end of the year, mostly because it's an election year and you have the House running for election. So one good thing is that since this didn't get on the ballot, kind of going back to the history, it's just an amended law. So it just takes 50% plus 1 to amend. So that makes it a much easier threshold than if it was on the ballot. It'd have to be a 2/3, 2/3 or 3/4, sorry, vote. Unfortunately, we do not know where the governor is on this. Much of the news in this week has been the governor and her staff determining what they need to do to implement the act and how they can help employers implement the act, not that they're willing to change it. So we will definitely keep you up to date on any changes on amendments to the Earned Sick Time Act.
Thanks, Joelle. Another question I had that applies to a lot of our members who are located out of state. If a company doesn't have an office in Michigan, doesn't have a physical presence in Michigan, but they have employees who are servicing or selling to Michigan clients, does this law impact that company located in another state or the employees here?
Well, I think that would be a determination on, whether or not that individual was a Michigan employee, which, there's question as to where do they sit? Are they working remotely in Detroit and, technically in another state's office? Or are they just, sitting in another state and servicing clients in Michigan? I think if they're sitting in another state and servicing clients in Michigan, you probably don't need to comply with this. But again, the definition of employee is so broad. It's, an individual in the service of an employer, which is everyone. So I think it's sort of a fact-specific question, but assuming, a person isn't sitting here and working remote in Michigan just for an out-of-state company, you're probably okay, but I would look at that.
Well, and I heard this on another webinar about this topic. How about individuals or service providers like landscaping companies or cleaning companies that are providing services to a Michigan business? What is that? What would our members' responsibility be toward that other company that they hire?
So I think that comes into the question of, are independent contractors covered under this policy or under this statute? I think that the answer is it depends, because of the such broad definition of employee. It would kind of undergo that independent contractor versus employee analysis, where are they someone that you can control, that you tell them when to show up, that they don't work with anyone else, or is it a landscaping company that you're just one of many different clients, they hold themselves out to the public as their own business, they don't do what you do, they bring their own materials, things like that. I think that's the sort of analysis that you go through, assuming you fall into the latter, where the landscaping company isn't what you do and you're not controlling them, then no, I don't think you need to give them paid sick leave. But if there's a question, I think it implicates, a couple different areas. But if you're currently treating someone as an independent contractor and not, doing all the things that you normally would do if they were an employee, I'm not sure I would change what you're doing, for a couple of reasons. The most important is that if you did get hit with a misclassification audit, I think the first thing, if I was the Michigan agency, I would say, well, you're giving them sick leave, but you're saying that they're not an employee. So I think it's kind of a fact that cuts against you if you did give someone sick leave, but you were saying they're an independent contractor. So I think I would treat contractors the way that you're treating them right now, with the caveat of there is some risk because of how broad the statute is drafted and just sort of the general trend against independent contractors in Michigan.
Tiffany asked a question, but before I get to that, you just triggered a thought. Who's going to be deciding the answers to these questions? Does everybody have to go to court? Is the Department of is Leo going to weigh in with standards? I mean, what's going to happen on that front?
It's a good question. We don't really know right now. It could be Leo. The Attorney General could come out with a sort of compliance opinion. I think, what's more likely is that plaintiffs' attorneys are going to start suing on these things, and then the courts are going to have to interpret the statute. But right now it's up in the air. I would guess, any or none of the above. But I think one thing for certain is that there are going to be lawsuits on this thing.
And Tiffany asks, if they currently allow staff to roll over any unused sick time into regular PTO, will they have to roll it? Will it have to roll over into specific sick time bank, or is it fine as long as we allow them to roll over sick leave in general?
That's a good question. I actually haven't heard that one before. The statute says that you have to allow them to carry over all earned but unused sick time. Now, where you carry that over to, I think is up to you. This is kind of a combined PTO policy question plus a carryover question. So, it depends on the policy. I would need to take a look at the policy. Everyone's policy is different. You're probably okay so long as you're allowing them to carry it over, and you're tracking the accrual, and you're making sure that you know how much the employee is accruing on a yearly basis.
Jay asks if it would be wise to have a must follow Michigan sick leave policy clause written into contractor contracts.
Yeah, I mean, that's definitely something that you could put into your independent contractor contracts. Obviously, if you're contracting with a temp agency or another company that is going to be providing these services, that's the best way to do it. Dealing with individuals personally, it opens you up to a little bit more risk on the independent contractor side. Because, from the government's point of view, someone should be paying sick leave. They don't like independent contractors. So if you have a temp agency, presumably the temp agency is providing the sick leave. And if you're contracting with a landscaping company who will be providing those landscapers, presumably that company will be providing the sick leave. So I don't see any reason why you couldn't put that language into your independent contractor contracts.
All right. Derek asks, in the hypothetical that a company offers an unlimited PTO bank, would that in theory meet the stipulations of ESTA?
Can you repeat that one more time? I'm sorry.
If a company offers an unlimited PTO bank, would that in theory meet the stipulations of ESTA?
So this is another good question. And until we get a little bit more clarity from the courts or from Leo or someone, we can't know for sure. What I'll say is that, from a practical perspective, if you were sued, but you give someone at least as much, or if you give them unlimited sick leave and PTO, and you tell your employees you can use as much as you want. Here are the reasons you can use it. Like from a practical perspective, you can take the position, no harm, no foul. But the thing that gives me a little heartburn is those liquidated damages and the attorney's fees provisions just for a technical violation of the statute. Hopefully we'll have some clarity from the courts soon, but that your question was actually addressed in California, where a lot of the tech companies give unlimited PTO. And the courts there essentially said, no, you're giving them as much. The purpose of the statute is to allow employees to have sick leave. You're giving them as much sick leave as you want. Get out of here. So hopefully that's the way that the courts will also review it here. But right now, we don't know for sure. I think you're muted, Scott.
That's pretty good. Only one time so far. I don't see any other chat Q&A, but how precise does an employer have to track an employee's sick leave? Is it daily, hourly? Do they have to do it every 6 minutes? Somebody takes 45 minutes off. What is the law? What does the act say about tracking that time?
So your question goes to the increment of use. So you the employer can set the sort of increment of sick leave use, and the statute says that you have to allow employees to use like the smallest increment that you use under your payroll policy. So if your payroll company tracks time at an hour, that's how you would track the sick leave used. Does that answer your question?
Yes. Answers my question. I don't know if anybody else has follow-up on that. My last question was based again on a different webinar where it was basically said that if you hire a babysitter, this applies to individual people. Like if I hire a dog walker, are they covered? But I guess my question is, are they covered? But how many hours does somebody have to work for you before they're considered an employee?
So, again, this gets back to that definition of employee under the statute where it's an individual in the business, or I'm actually going to pull it up right now so I can read it to you exactly. It is employees defined as an individual engaged in the service to an employer in the business of the employer. So you can certainly take the position that means everyone who receives a paycheck under the sun. It's written that broadly. Now, for a babysitter, I think I would undergo a little bit of that independent contractor analysis here, where, are they babysitting for anyone else? Are you telling them when they can and can't show up? How long have they been a babysitter to you? All of these things to determine whether or not that person is an employee under some of the other tests before I would just jump to be like, okay, I'm going to give you paid sick leave. Because again, it's kind of a double-edged sword where, if there's a question on whether or not someone's an independent contractor, they're going to look at that and be like, you're giving them paid sick leave, but you're saying they're a contractor. So that's a non-answer to your question. But what we've seen is that we'll get questions on election workers, someone who comes and works for a couple weeks at a time. Do I have to give them paid sick leave? The answer is probably yes, but the big thing is that you're accruing time 1 hour of sick leave for every 30 hours worked. So hopefully when you have these sort of temporary or part-time employees, while they are covered here, they're going to be accruing time at such a slow rate because they're not working all of the time that hopefully we're only talking about like a couple hours here max.
Okay. I think you can all unmute yourselves. Does anybody have any other questions for Tony?
see, Mary asked the question, if I hire a house sitter that works 2 to 3 weeks per month, they go to their 9 to 5 job during the day, but live at my house during those 2 to 3 weeks. Again, you know, it's a fact specific inquiry. Do I think anyone's coming after you? I don't know. You know, I suppose your house sitter could start making complaints to Leo saying that you're actually an employee. So it's possible that you could get hit there. But again, it's those facts on, you know, how much do you control them, how much they're working, the hours of the relationship, things like that.
Okay, anything else?
Can an employee waive their rights to these conditions?
That's a good question. I don't believe there's anything in the statute that prohibits that. So the statute doesn't expressly deal with it. Whether or not, you know, a waiver would be enforceable in court, I don't know, but could it hurt to put that in an employee contract? I don't know. I would have to think about that one. I'm not sure.
Any other questions? All right, well, Tony, you provided your contact information on, I think, the first slide. We are going to make this presentation available to our members. But I want to thank you again for presenting this. There's going to be a lot. Obviously, there's a ton of questions that people are going to have as they get into the specifics and look at their manuals. And they can reach out to you. You can also talk with Mike Ramp in our office, and he and Tony can work together on things. So any final thoughts, Tony?
No, just thank you so much for having me. Nice to speak with you all. I'm going to put my contact information in the chat as well. You know, if anything comes up, you know, we've got some great employment lawyers over here at Foster Swift, so happy to help. You know, I know it's a crazy time, and we're getting lots of calls every day about reviewing handbooks and policies. So anything you need, give me a call.
Great. Thank you very much. Thanks, everybody.
Thanks, everyone.
Bye.